everyone. Well, wonderful to see all of you here who have signed up for Maxwell lectures. This is the first time we are conducting this as an online webinar. Just some administrative matters before we begin. For participants that are claiming their 1 CPD point, it is mandatory to stay throughout the webinar to verify your attendance. Participants who do not stay throughout will unfortunately not able to claim their CPD point. Please rename yourselves as your actual name so that it will allow us in attendance tracking. We will also have a short 15 minutes Q&A later where you will be able to type in your questions in the chat box below at your screen there. So moving on. Dr. Sharad is a barrister and practices in construction law as an arbitrator, expert determiner, mediator, and member of dispute boards. He is a member of the FIDIC President's List of Adjudicators and an accredited FIDIC trainer. As Senior Fellow at Melbourne University, he co-presents a master's course in international construction law. Prior to becoming a lawyer, he worked as an engineer for over 30 years. Dr. Sharad has published widely and presented numerous conference papers and training courses. He is the author and editor of 5 books on construction law, including The International Application of FIDIC Contracts, a Practical Guide. The title of today's Maxwell lectures is Lex Constructionis, All My Country's Rules. This lecture explores the questions of whether there are universally accepted principles of construction law, a lex constructionis, or whether it is trumped in every jurisdiction by local laws that differ from international norms. So now I'll be passing over the time to you, Dr. Sharad. Welcome.
Thank you very much, Azwin, for your very kind introduction. I'd like to start my talk by acknowledging the traditional owners of the land that I'm speaking from today and would pay my respects to their elders past and present. Good evening, ladies and gentlemen, or good morning or good afternoon to everybody, depending on what part of the world you're in. I express my thanks and appreciation to Ms. Catherine Yap and Maxwell Chambers for the honour and privilege of addressing you tonight in this first Maxwell Zoom. If there's one silver lining to the COVID-19 pandemic, it's that we now have international opportunities to get together by Zoom without the time and expense of travel. There are over 200 people from a number of countries who have registered for tonight's Maxwell lecture, many of whom would no doubt have been unable to attend a traditional in-person talk in Singapore. My regret at not being able to visit Singapore at this time is more than compensated by the international interest in this talk tonight. Please bear with me for a moment whilst I share my screen so we can look at my slideshow. As you've heard from Azin, the topic is Lex Constructeonus, or My Country's Rules. I've given you there my email address. I'm very happy to hear from anybody who would like to discuss this further. I'd be particularly happy to hear from anybody who has a different view to my perspective on this topic. I've also given you the website address of Expert Determination Chambers, and you'll find in that a number of papers, some of which are quite relevant to tonight's topic. Now, I've got quite a number of detailed slides, but I understand Maxwell Chambers will make these available tomorrow for anybody who's interested. So the agenda for tonight's talk, on the assumption that perhaps not everybody is a construction law practitioner, I'll start with looking at some particular features of construction contracts. I'll then take my topic in the reverse order. I'll look at the My Country's Rules first, what I'll term International Contract Law 101. I'll go over some basics with which you're probably all very familiar and look at a couple of areas where local rules apply, statutory incursions into freedom of contract, and public policy constraints on freedom of contract. I'll then look at what is this Lex Constructionis and why I think it's important. And I'll go through a couple of examples that might indicate some aspects of it. But I'll look in more detail at three things. First of all, these FIDIC contracts, which I'll define and explain more in due course. International commercial arbitration, although I suspect in this venue, it's probably hardly necessary to say much about that. I'm sure everybody is very familiar with international commercial arbitration. And then I'll talk about the UNIDROIT principles of international commercial contracts and a modern expression of what might be termed the lex mercatoria, the law merchant. To relate all of this to where we sit tonight in the midst of a pandemic, I'll look at briefly government responses to the impact of COVID-19 on construction. And then I'll finish with my proposed principles of Lex Constructeonus. So let's start with construction contracts. Construction law, of course, is the law relating to construction projects. Typically deals with aspects of design, construction, maintenance, and operation. The legal mechanism for the delivery of a construction project is a construction contract between employer and contractor. But construction contracts, as a species of commercial contract, I think have some features that make them sui generis, a category of their own. I'll look at those aspects under headings which are probably familiar to all of those of you who are familiar with construction law, dealing firstly with scope. The subject matter of a contract, the contract relates to construction of a unique facility which will be affixed to the land at a specific location over a specific period of time. That constructed facility becomes part of the real property of the landowner when it's attached. The required design, scope, time, cost, and quality requirements of the works and the finished project are usually defined by extensive and complex technical documentation. The employer generally has the right to increase or decrease the originally agreed scope of work by the issue of variations, and the contractor is obliged to carry out or omit that varied work. That's clearly an issue of contract. Without such a term in the contract, there would be no right of the employer to change the agreed scope of work. And yet variations are very common and effectively essential in construction contracts. And the execution of construction work or the performance of the contract may be supervised by a person who's not a party of the contract. Typically someone who's called the engineer, perhaps the architect, or a project manager. There are many risks in a construction project. To use Donald Rumsfeld's three categories: known knowns, known unknowns, and unknown unknowns. Ground conditions in particular, they're never completely known, including geotechnical conditions, groundwater, contamination, or heritage items. And that's usually irrespective of the extent of site investigation that's been carried out beforehand. Weather conditions can have a significant impact on construction activities and delay completion. This freedom of contract that I'll be talking more about may be significantly constrained. Security of payment legislation in particular mandates payment obligations and makes some provisions illegal. Many aspects of a construction project are subject to government laws and regulations. And there are usually a series of independent and interrelated contracts between a number of different parties. We've got the employer consultant, the employer contractor, contractor subcontractor, contractor security, contractor insurer. All of those contracts are relevant to the project. The long list of risks in a construction project goes on. They involve significant environmental impacts: noise, dust, smells, vibration, nuisance, water runoff, sediment and erosion. The construction might adversely impact adjacent property. The activities involved in construction are potentially dangerous to the workers. There's heavy machinery, there's working at heights, working in confined spaces. Insurance of the works is often mandatory and is a significant risk transfer mechanism. And insolvency of parties, both to the construction contract and to interrelated contracts, is a very real risk. Under the heading of time, many major construction projects take place over a number of years, including a period after completion of construction when the employer is in possession of the site, during which the contractor is liable to rectify defects. And of course, there are usually significant financial consequences for the contractor for late contract completion. Under the heading of cost, contract sum and cash flow, typically substantial. Contracts in the tens of millions, the hundreds of millions, or even in the billions are commonplace around the world, and the cash flow involved in such projects is really substantial. Because of the importance to the employer of the contract being completed, contractors usually required to provide security for its performance. Quality, of course, is an important issue. It might involve the assumption of obligations that are very long term, maintenance or liability for defects arising many years after construction was completed. And of course, another risk aspect, the work apparently completed in accordance with contractual requirements might contain latent defects, which only manifest themselves many years after construction was completed. And something perhaps dear to the hearts of many people tonight, disputes. They're common and frequently involve complex technical issues and large volumes of documents. So to sum up on construction contracts, a construction contract's a legal mechanism to deliver the construction project, and that's a theme I'll keep returning to. A construction contract typically addresses the issues of scope of work, allocation of risks, the time for completion, payment, quality, and provisions for dispute resolution. I've called this next brief section International Contract Law 101, something which I'm sure everyone will be familiar with, but I'd just like to set the foundations for my Lex Constructeonus. And I think it's based ultimately on two universal principles of contract law: freedom of contract and pacta sunt servanda, the Latin expression which means that agreements are to be kept. I think it's well to remember also that freedom of contract can only be exercised, and this pacta sunt servanda really only has meaning in a jurisdiction subject to the rule of law. So those are foundation principles that our Lex Constructionis is based on. Freedom of contract, a brief definition: ability of legal persons to enter into binding contract to do anything, providing it's not contrary to the law or public policy, and in some jurisdictions, contrary to morals. It's a long-standing common law principle. I've quoted a case there from 150 years ago, which I think is still relevant today. And courts have a natural bias to uphold freedom of contract and take a very narrow view of any constraints that the legislature puts into place that restrains that. I've quoted there one of our High Court judges in Australia from some years back. Freedom of contract, of course, is enshrined in civil law codes. I don't need to read those. The French Civil Code, the Philippines, the Russian Civil Code, they all say very similar things. And we also have a couple of statements from this Lex Mercatoria, the law merchant, law that is independent of particular jurisdictions. And I'll be coming back a little bit later to the first of these, but there are two modern expressions of the Lex Mercatoria: the UNIDROIT principles of international commercial contracts and the Trans-Lex principles. And both of these have very simple and straightforward expressions that provide contracting parties with freedom of contract. It's important because it allows the contracting parties to select the governing law of the contract, to agree on the scope of their rights and obligations, to agree on the allocation of risks between themselves, and importantly, to agree to resolve their disputes by private and confidential arbitration by an arbitrator of their choice in accordance with procedures they've chosen. Well, the obverse of that principle of freedom of contract, where parties have the freedom to enter into a contract of their choice, is that once they've exercised that freedom, they have the legal rights and obligations they've agreed to, and those rights and obligations are enforceable by a court. If they've agreed that any disputes will be settled by arbitration, the courts will generally stay any court proceedings commenced in breach of their agreement to arbitrate. I like this quote I provided here from Robert Knudsen's book of some years back. The principle of pacta sunt servanda is universal to all legal systems, and this means that the vast majority of construction disputes are fought, won or lost primarily over the wording of the contract and alleged facts. So to sum up my International Contract Law 101, we have the two principles, universal principles: freedom of contract, pacta sunt servanda, but there are constraints on those freedoms, and the important ones, particularly that we're dealing with tonight: statutes, legislation passed by our governments. There's also public policy, and in some jurisdiction, morals. Let's have a look at what are some of these statutory incursions into freedom of contract. Well, every statute whose subject matter is relevant to the content of a contract potentially impacts on freedom of contract by prescribing certain required conduct in particular circumstances, or proscribing certain conduct in other circumstances. I've listed there two categories of laws relevant to construction. It really should be three. The first one is project related. That is, laws subject to the jurisdiction of the site where the works are carried out. There is contract related laws subject to the jurisdiction of the governing law of the contract. And the third one relates to dispute resolution. And we're particularly interested in international arbitration. And there are laws relating to arbitration where the seat of that takes place. Project-related laws are any applicable laws impacting on any aspect of a construction project that explicitly constrain the party's freedom of contract, particularly in how the work can be carried out and how it impacts on third parties, such as laws relating to labour, health and safety, the environment. And I think it's fairly clear that laws relating to activities, people and property at the site of construction will generally apply irrespective of the governing law of the contract. A couple of examples of project-related laws. There are, of course, many of them around the world, but there's a law on subcontracting in France that puts in place protective measures to protect the interests of subcontractors. Also in France and various other countries, there's what's called decennial liability. Liability generally for the partial or total collapse of structures that occurs within a period of 10 years after construction's completed. Then there's a couple of examples of contract-related laws from Brazil, South Africa, the UK. Again, if we look around the world, there are many examples of these. In terms of common law jurisdictions, perhaps the greatest incursion into freedom of contract ever, certainly in recent times, is what we'll call statutory adjudication legislation. That is legislation that provides a statutory right for disputes to be determined provisionally by adjudication. The UK led the way in 1996 with the Housing Grants, Construction and Regeneration Act. The 8 jurisdictions in Australia followed from 1999 over the succeeding years, and the number of other jurisdictions have also followed: Singapore, New Zealand, Malaysia, Ireland, and the province of Ontario in Canada. That legislation constrains contract in various ways. Obviously, there are differences between jurisdictions, but each of these heads here applies to constraints that applies in at least some of the jurisdictions. That is, that they provide for such things as statutory entitlement to progress payments, an automatic entitlement to payment if formalities are not observed. In some of the Australian jurisdictions, if the payer does not put in a payment schedule, then they're liable to pay the total amount of the claim without any defence to that. There's no contractual defences generally to court enforcement as a judgment debt once the procedures have been followed. Various clauses such as pay when paid and pay if paid clauses are void. A non-paid party may stop work. And because of the significance of this legislation, it's legislation that cannot be contracted out of. Parties typically have the right to submit a defined type of dispute to adjudication. Apart from England, most of the other jurisdictions confine these disputes to payment disputes. There are defined formal dispute adjudication procedures and strict time limits for that adjudication. The parties might not be able to choose their adjudicator. And some legislation provides for project bank accounts to provide security for subcontractors. There's a trust over monies payable to them, mandated by the legislation. We shouldn't underestimate the significance of this legislation because it has made a substantial difference in the common law world, where previously much of our law was based on the common law. We now have much more legislation that applies. We can look at many civil code provisions. For instance, there's a couple here where, in spite of agreements in a contract on liquidated damages or delay damages, under some circumstances, the courts can increase or decrease these. There are provisions on relief from hardship in various civil codes. I don't need to read these out, but I think there might be a lot of people in the civil law world who'd be very happy to have provisions on hardship in their contracts in the circumstances we find ourselves in. So, to summarise, those statutory incursions into freedom of contract are typically going to be project related, where they're subject to the jurisdiction of the site where the works are carried out, or contract related, that is subject to the jurisdiction of the governing law of the contract. Looking briefly at public policy constraints. Public policy is largely concerned with the potential for manifest unfairness or injustice in a given situation. And courts might disregard or refuse to give effect to contractual obligations, even if they're not directly contrary to any express or implied statutory prohibition, nevertheless contravene the policy of the law. Here's a few examples. Imposing a penalty for breach of contract, unlawful conduct prejudicial to the administration of justice, ousting the jurisdiction of the courts, economic duress, application of illegitimate pressure to achieve an agreement, or exclusion clauses in conflict with public policy. Many more examples could be quoted. Well, that's the My Country's Rules bit of my talk. Let's move on to what the talk's perhaps really all about, Lex Constructionis. What is it? Here's my brief definition. The law of international construction in jurisdictions subject to the rule of law and which recognise the parties' freedom of contract. I think it's composed of the governing law of the contract between the parties, the law applying to the project of the site, and the law applying to the final resolution of disputes. It provides a legal framework within which the parties' legitimate expectations can be realised. And I think it offers the prospect of best practice for successful projects. What's the theoretical basis of Lex Constructionis? Well, I think there are three theories that can be derived from the broader category of lex mercatoria, the law merchant. The first is that it's just a mass of rules and principles for the law of construction, devoid of any internal consistency or systematic quality. In that case, it would be decided according to the well-known categories of applicable domestic law. The second theory is that it's the totality of usages that are refined according to the needs of construction. And that would be decided according to statutory or judicial acceptance of trade usages as a factual supplement to the applicable domestic law. But I think the most significant and potentially most valuable is the third, which is the one that personally I support, that it's an independent supranational legal system. And we'll be talking about the UNIDROIT principles later, but that can provide the framework for a supranational legal system. Why do I think Lex Constructionis is important? Well, construction projects provide the infrastructure on which our modern life depends. We only have to think about all the infrastructure that is involved in all of us being together virtually tonight from many countries around the world to think about the infrastructure that's provided by construction contracts. Construction projects are essential to improving the health, quality of life and living standards in less developed countries. Construction industry is a significant component of the world economy, and it's also a very significant employer. I think typically in developed and less developed countries, construction often amounts to 10% or more of a country's economy. And Lex Constructionis, I think, can lead to better value for money, less expensive projects, fewer disputes, and fewer insolvencies. I think it can also promote international trade and greater comity between nations, perhaps something that is sorely lacking at the present time. I'll have a look at a couple of examples that give some indication of what might be in Lex Constructionis. Firstly, I think there's a significant convergence between the common law and civil law. Much more of the law in common law countries is explicitly stated in legislation. It either codifies or amends the existing common law or forms new social legislation which mandates desirable community outcomes not achieved by the common law. A brief discussion of that security of payment or statutory adjudication legislation, I think, is a typical example. The courts in civil law countries are relying to a much greater extent than previously on the precedential value of court judgment on a similar issue, because the answer to a legal issue might not be found in the codes, which are typically at a theoretical level and established principles. And I think despite the difference between legal theories, form, procedure and terminology, in many factual situations, the two systems, that is common law and civil law, will arrive at essentially the same substantive result. I think fortunately all roads lead to the Rome of a just and equitable outcome. The second example I'll take has a great historical relevance. Going back to the Code of Hammurabi, nearly 4,000 years ago, which I think is the oldest known written legal code. Here's a few of the sections that relate to building. I'll skip over the first three, but if a builder builds a house for someone and it ruined goods, he shall make compensation for all that's been ruined. And inasmuch as he did not construct properly this house which he built and it fell, he shall re-erect the house from his own means. And the following one along a similar line. Both of those provisions indicate that the builder who was responsible for defective work had to pay damages or repair the defects at his own expense. Things haven't changed much 4,000 odd years later. In the Supreme Court in the UK in 2017, a contractor was liable for the structural failure of wind turbine towers that occurred within 2 years of installation. And the liability was there even though the failure occurred a result of an unknown error in the specified design standard and in the absence of negligence. And I'm sure many of those looking in tonight will be familiar with the case, the wind farm case. And my third quick example, just on force majeure, many civil codes have specific provisions relating to relief in the event that there are unforeseen circumstances which occur after the contract's been entered into that can't be controlled or avoided by the parties. I won't bother reading all of this, but I think if you look at the clause 18.1 and 18.4 in the FIDIC Rainbow Suite, which I'll be talking more about in a moment, the definition of exceptional events and the consequence of that are very similar to the provisions of force majeure in a number of civil codes. It's probably a good segue into a more detailed talk on FIDIC contracts. For those of you who are not familiar, FIDIC, the acronym stands for the French name of the International Federation of Consulting Engineers. It publishes standard form conditions of contract used in many countries. There are pictures of the covers there at the bottom. As you can see, they have different colours. They're typically known by the colour of their covers. The red book, the yellow book and the silver book, which have recently had a second edition in 2017. There's also the short form of contract, the green book, which is probably very important because it's used widely for organisations such as the United Nations for smaller contracts. These contracts are typically referred to as the Rainbow Suite. FIDIC does publish a number of other contracts as well, such as dredging, a design, build, operate contract, subcontract and so forth. But for present purposes, we'll confine our attention to this Rainbow Suite. These FIDIC contracts are drafted by a contracts committee and reviewed by friendly reviewers from many different countries and jurisdictions. That is, there's substantial international input. They do have a common law heritage in that the first version of FIDIC contracts was based on the institution of civil engineers contract. But notwithstanding that civil law heritage, they're used in many common law and civil law jurisdictions. I think they're definitely the most widely used for international construction contracts in the world. It's the general conditions that FIDIC publishes in their books, and typically these need to be amended by particular conditions to comply with the governing law of the contract or the law of the site where the works are performed. Now, I've put in this what you might think of as an advertisement for this recently published book for two reasons. The first is that it's actually the reason why we're all here together on the Zoom tonight, because the CEO of Maxwell Chambers, Ms. Catherine Yap, kindly agreed to launch this book in Singapore in January, and it was a result of that offer that I was invited to give this talk tonight. But also, I want to acknowledge the work done by the authors of all these chapters. My role was editor. I wrote a couple of introductory chapters and a chapter on Australia, but there are 17 other chapters on a number of jurisdictions around the world there, and the authors of those chapters are listed. And their work, I think, has made a great contribution to this international application of FIDIC contracts, and perhaps to the broader concepts of Lex Constructionis. And I would like to acknowledge and thank those authors for the work they've done, and I've used significant parts of that material in preparing for tonight's presentation. And I'd also acknowledge that several of those authors have also provided me with some up-to-date detailed information on the impacts of COVID that I'll be talking about. I provided a chapter template for each jurisdiction for this book, and the contents of that template are listed there. But the one I want to focus on is the fourth bullet point there. What special provisions in the particular conditions are necessary for consistency with applicable laws? And there are three separate categories there. Firstly, where the general conditions are incompatible or inconsistent with the governing law of the contract. Secondly, where they're incompatible or inconsistent with the law of the site or the country where the construction is taking place. And thirdly, where the general conditions are incompatible or inconsistent with the laws of the seat of the arbitration or relevant laws on dispute determination. The other aspects of that chapter template are listed there. I won't go into them in detail, but I'll just point out that each of those chapters has a table of applicable legislation under those three categories. And I believe that's a very valuable resource for anybody who's entered into, dealing with, or administering a FIDIC contract in a jurisdiction in which they're not familiar. So extracting some very important information from those various chapters, this table is the first of those requirements for where there would be particular conditions necessary because the FIDIC general conditions are incompatible or inconsistent with the governing law of the contract. There's no need for me to go into the details of what these are. I think what you need to note here that of the 18 jurisdiction chapters we have, only 11 of those chapters of those jurisdictions actually require special conditions to comply with the governing law of the contract if that's in the jurisdiction. Most of the common law jurisdictions do not need any special provisions, and nor does if the governing law is that of Switzerland. whilst there are a number of bullet points there, given the complexity of a construction contract, the work that it regulates, that table, I think, indicates a relatively small number of areas where FIDIC contracts need to be amended for specific jurisdictions. The second, much smaller list is where we need special conditions, particular conditions where FIDIC general conditions are incompatible and consistent with the laws of the site or country. And we've only got 4 jurisdictions there. The other 14 jurisdictions, we don't need any particular conditions for consistency with the local laws of the site. And a very small list for that third category where the FIDIC general conditions are incompatible or inconsistent with the laws of the seat of arbitration or relevant laws on dispute determination. And neither of those jurisdictions do those particular conditions relate to arbitration. They mainly relate to dispute boards. So in summary, in relation to FIDIC contracts, they're the most widely used international standard form contracts. They've been drafted with extensive international input. They're suitable for common law and civil law jurisdictions. The particular conditions essential for conformity with local law are limited in number. They've been implemented by the World Bank in its most recent standard procurement documents, certainly complemented by a significant number of particular conditions, but those particular conditions are generally to cover issues that may not be provided by laws of the countries where, perhaps less developed countries, where some of the projects funded by the World Bank take place. And I think these FIDIC contracts are perhaps the closest to an international norm construction contract. Well, I think I can deal very briefly with international commercial arbitration, but I'll make a few points. It avoids any perceived home country bias in the courts. By definition, an international construction contract involves parties from different countries. International arbitral tribunals typically comprise practitioners from different jurisdictions and legal systems. The New York Convention is fundamental to the widespread acceptance of international arbitration because it means that court proceedings can be stayed to permit arbitration as chosen by the parties, and perhaps just as importantly, it provides for an enforcement mechanism of arbitral awards in many jurisdictions. The international nature of and support and acceptance of arbitration is very much also dependent on international organisations that promote principles, rules and procedures that are widely accepted as international norms independent of legal systems. And it's worth noting that the arbitration law in 116 different jurisdictions is based on the UNIDROIT model law. International organisations, there are many of them. These are perhaps just the ones that most commonly come to mind. UNIDROIT, the United Nations Commission on International Trade Law, the author of the New York Convention, and of course the UNIDROIT model law and the rules. The IBA, the rules on the taking of evidence in international arbitration published by the IBA is well known and widely used. The Chartered Institute of Arbitrators, which has many members in many countries, publishes guidelines, codes of ethics, rules, etc., of great assistance to arbitrators. There's the International Chamber of Commerce, which in one sense should be at the top of the list, over 100 years old and has been administering arbitrations for a very large portion of that time. And then we have the many important international arbitration centres, Singapore, Hong Kong, London, etc., etc. There are many of them, and they are very important in administering arbitrations and promoting common practices and procedures. So in summary, in relation to international commercial arbitration, freedom of contract means that parties can agree to resolve their disputes by arbitration instead of litigation. It's accepted in the majority of countries as a binding method of dispute resolution. The New York Convention enables enforcement of an arbitral award through the courts of any convention country. There's consistency in much arbitration law because of the adoption of the UNIDROIT model law, and there are widely accepted norms of international arbitration promoted by many international organisations. Well, to move on then to the third of these elements that I think is contributing to Lex Constructionis, the UNIDROIT principles of international commercial contracts. UNIDROIT is the International Institute for the Unification of Private Law. It actually dates back to the 1930s. It was originally an organ of the League of Nations, but has since evolved into an independent intergovernmental organisation with its seat in Rome. It studies needs and methods for modernising, harmonising and coordinating private and in particular commercial law as between states and groups of states. There are 63 member states, and those members are drawn from the 5 continents and represent a variety of legal, economic and political systems, as well as different cultural backgrounds. It is a truly international organisation. Well, what are these UNIDROIT principles? They're a set of national principles apply to the formation, validity, interpretation, performance and termination of commercial contracts. They're a modern statement of a lex mercatoria for international contracts. They're drafted by legal experts from many countries, common law and civil law. The rules are not derived from any particular national law, but they embody contractual principles which are or can be recognised by the laws of any country. I think their purpose is very well summed up in the preamble, and that's the exact quote there. They set forth general rules for international commercial contracts. They shall be applied when the parties have agreed that their contract be governed by them. And that, I believe, is potentially a bedrock principle on which Lex Constructionis can be founded. But even in the absence of parties selecting UNIDROIT as their governing law, there are a number of other applications of these principles, and there's considerable documentation available of how courts and arbitral tribunals have applied the UNIDROIT principles in a variety of circumstances under those bullet points there. It's interesting to note that even in my own common law jurisdiction of Australia, our courts have been quite active in referring to the UNIDROIT principles as support used to interpret or supplement domestic law. This table indicates, firstly, that there have been 4 editions starting in 1994. The 94 edition had 120 articles. Subsequently, the 2004 editions had another 65 articles because it introduced a further 3 chapters, and they're shown there, chapters 8, 3 chapters, chapters 8, 9 and 10. Then in 2011, we have a further chapter added, which adds another 30 odd articles. The 2016 edition perhaps is strictly not entirely new. It has the same number of articles, but it has updated some of the provisions to take account of some modern changes. I think what that chart shows quite graphically is that this is a living, evolving document. It's by no means static. UNIDROIT are conscious that the world moves and it needs to move with it, and accordingly has updated these principles on a number of occasions. The benefits of using these principles: they're a private codification of civil law approved by an intergovernmental institution. They're not treaty, compilation of usages, or standard terms of contract, but they're in fact a manifestation of transnational law. And the two quotes I've provided there, which I don't need to read, both come from ICC arbitrations where the arbitral tribunal found these principles to be very valuable as a source of international commercial law. To take briefly a couple of examples of clauses in the UNIDROIT principles on hardship and force majeure, and the ones I'll be talking about have actually been introduced either literally or with few modifications in a number of national civil codes, including the ones listed there. I'm not going to read these articles. I'll just leave them on the screen briefly there, but I'll make the observation that these articles on hardship and force majeure, I think there are a lot of people with common law contracts in the current environment who would be very glad to have provisions such as this that can be adapted to the circumstances we find ourselves in with COVID, which I think inevitably are going to lead to a substantial number of disputes. So UNIDROIT has dealt quite comprehensively with this, and clearly these provisions can only be guidance. They always need to be applied to the circumstances of the case, but they do provide a real roadmap. So in summary, these UNIDROIT principles represent a set of overarching principles appropriate to regulate an international contract. They can be used as the governing law of the contract where the contract has an arbitration clause, and they are a modern statement of the Lex Constructionis. Well, let's look briefly at the government responses to the impact of COVID-19 on construction. In terms of the execution of construction projects, there's a whole lot of actions that the countries have taken. I don't need to read these. I think most of you will be very familiar, perhaps at first hand, with lots of these things. But I think there's been a great deal of common approach to how governments deal with the impact on construction projects. Looking at construction contracts, time doesn't permit dealing with this in any detail, but just looking at a few jurisdictions, and I'm grateful to some colleagues for providing information on jurisdictions with which I'm not familiar. But looking at this, with the exception of Singapore, the common law jurisdictions there basically have done very little in relation to specific legislation that relates to COVID. Singapore is the standout. In terms of the civil law countries there, in some senses, perhaps they don't need to do as much because there are force majeure provisions in their contracts, but nevertheless, some of those jurisdictions have taken other actions as well. In summary, I think in respect of the operation of construction projects, governments have responded in very similar ways to stop the spread of COVID by almost universal agreement on appropriate health measures. Arguably, that's a manifestation of Lex Constructionis. Perhaps in respect to the operation of construction contracts, where governments have taken different approaches, it indicates that maybe we need to pay a little bit more attention to implementing Lex Constructionis. Some governments, I think, have dealt with it by benign neglect, leaving their parties to their existing legal and contractual remedies. We have got the great example of the Singapore legislation, the COVID-19 Temporary Measures Act, which has, I think, provided for some very substantial measures that will be of great assistance to the construction industry. And I note there that existing civil codes may well provide relief for a force majeure event, even in the absence of a contractual provision. And in respect of disputes, some governments have implemented new dispute resolution procedures, and two I'm aware of, the online dispute resolution scheme in Hong Kong or the assessor's determination in Singapore. Well, putting all this together, I've come up with my proposed principles of Lex Constructeonus. I suspect just about everybody looking in tonight will have their own views on what they should be, but for what it's worth, here are mine. And I've classified them under some headings which are relevant to construction contracts. First of all, we've got the overarching principles. I've stressed pacta sunt servanda previously. Rebus sic stantibus, that is doctrines or rules relating to changed conditions. We need that, particularly in the environment we're in now. Force majeure clauses, provisions in civil codes, of course, one example. The common law frustration doctrine is another. We need something to be able to deal with the fact that construction projects don't always go the way they're assumed to at the outset. And perhaps another one that might be controversial for some of the common lawyers, I believe the nature of construction, international construction contracts is such that the parties must act in accordance with good faith and fair dealing. I've then got a number of provisions there in relation to scope. I think we need a construction contract to be in writing so that we know unequivocally what the original scope is and the known conditions at the site. Clearly, we need the employer to have the contractual right to instruct variations consistent with the original scope of the contract, and the contract has the obligation to carry out such variations. The next two are issues that perhaps relate to the social obligations in relation to construction projects. Construction works must be carried out so as to protect the health and safety of workers, and they must not adversely affect the environment or the interests of third parties. Contractor needs freedom to do the work in the way that suits it best. It needs freedom to select the methods and timing of the works, subject, of course, to the contract. Risk. You recall my long list of risks that we have to deal with. I think the appropriate principles for a construction contract are those Abrahamson principles that are hopefully well known to you all, fair and balanced risk allocation. And number 11, the contractor is responsible for the works whilst it's in possession of the site. Time, always a significant issue in relation to construction projects. The first of those, number 12, not all contracts, I think, provide a reasonable time for parties to perform their obligations or exercise their rights. I think that's a particular manifestation of the good faith principle, which encompasses the concept of reasonableness. 13 and 14 are all about communication. The employer needs the contractor to communicate adequately and timelessly, and vice versa. I think many disputes start because the parties haven't appropriately communicated at the right time. And of course, the employer is very keen on having its project completed on the date that has been agreed, and the pacta sunt servanda principle is that contractors are liable to pay damage if it doesn't complete the works by the date it's agreed to. Money, of course, is at the heart of every construction contract. The employer must have adequate financial resources to complete the contract. The employer needs to know that the contractor has adequate financial resources to complete it, and therefore usually will want to have security for performance. And the one that probably is exceedingly important for contractors, prompt payment of contractual entitlements. In terms of quality, contractor either rectifies defects in its works or pays damages to reinstate the works to the contractually specified quality. And finally, in relation to disputes, unresolved disputes, that is, those matters that can't be avoided or resolved by alternative means, are finally determined by arbitration. My very brief final comments, bearing in mind that my own preference is for that third theory of Lex Constructionis, that is, an independent supranational legal system. I think the closest approach we can get, it can be achieved by use of an internationally accepted standard form contract such as FIDIC, use of the UNIDROIT principles or the trans-lex principles of the governing law of the contract, and an international arbitration as the final method of dispute resolution. And as I mentioned before, that final point, of course, is fundamental to being able to select a non-country governing law of the contract such as UNIDROIT or trans-lex. Thank you very much for your attention. I believe we have time for questions, and I'd be very interested anybody's comments on their own views as to whether the concept of Lex Constructionis is worthwhile, or perhaps what it should contain. Let me stop sharing my screen and hand back to Azwin. Thank you very much.
Thank you very much, Dr. Sherratt, for the insights that were shared. It was such an informative talk. So we will now proceed with the Q&A as discussed. Participants, kindly hover your mouse over to the Q&A button near the bottom of your screen and click the button to begin typing your questions. I'll be reading them out to Dr. Sherratt to answer. Oh, so quick. We have one here. Dr. Sherratt, so what are some of the challenges that construction law is facing in light of COVID-19?
That is a very good question. Perhaps I can quote the title of a paper I recently wrote, Construction Disputes After COVID, Jaw, or War. That is, are we going to be able to solve a lot of these disputes by negotiation and alternative dispute resolution methods, or are we going to have to go for the knockdown principles in adversarial litigation or detailed international arbitration, which are very expensive and very time consuming. I think if we only contemplate the magnitude of the challenges facing virtually every construction project and construction contract, there are inevitably going to be issues that need to be dealt with that potentially can result in significant disputes. I don't think there's enough time or resources available in the world to deal with these on an adversarial basis by litigation or arbitration. I think we have to look at negotiations, at various other methods such as mediation, dispute boards, but opportunities for parties to actually sit around the table and try and resolve issues non-adversarially. I think that is the biggest challenge we face, just because of the sheer magnitude and number of potential disputes that are out there.
Okay, thank you. So we have another one. Is COVID really a force majeure?
I'm going to pass on that one.
No.
I can take refuge in the standard lawyer's defence. It depends. It clearly depends on the governing law, and it clearly also depends on the individual circumstances. There is no way that anybody can make any blanket sensible comment to that. What I would suggest is look at the UNIDROIT website. There is a very good article there on UNIDROIT principles in the light of COVID-19. It's a very good paper that discusses various approaches and how various of the UNIDROIT principles can be applied in various circumstances. But of course, that paper makes the point is that every one of those principles has to be applied in the circumstances of the particular case that comes forward. There can be no blanket rule one way or the other. I might also just add, if you also look on the FIDIC website, you'll also find another useful document that canvasses the different possible approaches to disputes arising from COVID under FIDIC contracts.
Thank you. Okay, next we have, how has dispute resolution evolved due to such circumstances?
Sorry, would you mind repeating that?
Sure. How has dispute resolution evolved due to such circumstances?
Evolve.
I think due to such circumstances of COVID-19.
Oh, sorry, yes. I guess the jury is probably still out on this, because I think it will depend the extent to which parties are prepared to adopt these non-adversarial approaches. I don't think the circumstances of COVID necessarily require anything brand new, although I think the approaches that Singapore and Hong Kong have taken to introduce online, or in Singapore's case, assessor, I think that's a very worthwhile process. I'm sure there's a great deal of scope now that we're all very familiar with tools such as Zoom and Teams and so forth, and conducting meetings and so forth virtually. I think there's a great opportunity to take even established principles such as mediation, dispute boards and so forth, and to operate them virtually, even in the absence of being able to meet together. So I guess that's perhaps the most significant way in which I see dispute resolution is evolving. There will be much more being done online. I know Maxwell Chambers' website, of course, makes the point that it's open for business and it's able to assist the parties with virtual hearings or mixed hearings. I think there's a long way to go, and I think we'll learn a lot over the next period of time as to how we can deal with this appropriately.
Yes, Maxwell Chambers is here to assist at any point for your virtual or hybrid hearing. So thank you, Dr. Sherrod. So before we end the Q&A, I just want to ask if there is any other questions that the attendees might have before we close this. I think we do not have any more, Dr. Sherrod. Do you have any your last words or comments to the participants?
No, I'd like to again thank Maxwell Chambers and Ms. Yap for inviting me. I'm very honoured to have been able to deliver the first Maxwell Zoom lecture, and I'm delighted with the responses you've got. I think you've got a very good attendance from around the world, and I'm very pleased that to have been able to participate in this. So thank you very much, and thank all the attendees.
Likewise for us too, Dr. Sherrod. Thank you. We're so grateful for you to grace our first webinar. So thank you very much. And we also like to thank everyone for participating in this webinar. We hope to see you at our next Maxwell lectures. So please check back on our website or social media platforms for new developments. Okay, so thank you everyone. Have a great evening from Singapore. Bye.
Bye.